And welcome back. Now, in conversation with amaBhungane's investigative journalist Sam Soul, and this about a High Court victory yesterday that declared parts of the Rica Act unconstitutional. Sam, thanks so much for your patience this morning. So I'm going to have to ask us to just go back to your response to that first question of how you became aware that your communication was actually intercepted. And just to remind our viewers, this, of course, at a time when you were actually reporting on corruption against then President Jacob Zuma. So how did you become aware that your communication was actually intercepted?
Well, it was way back in the Sheikh trial when, in fact, President Zuma, then Deputy President Zuma, was kind of out of the picture. But my communications with the chief prosecutor in that case, Billy Downer, were intercepted. And we were not aware of that until much later during the spy tapes trial, which did in fact involve President Zuma. And among the interceptions that came out in the spy tapes trial was a transcript of that conversation, or those conversations between me and Billy Downer. So we could prove for once that I had been monitored, had been surveilled. And that was the springboard for this application. But this application obviously has much wider bearing than just on me or on journalists. It affects all South Africans, you and me.
So, Sam, part of the argument that amaBhungane had put forward was that Rica did not have measures to protect the public's right to privacy, and that it actually failed to inform subjects, as it did in your case, that they had been placed under surveillance. Please talk to us about that.
Yes. Look, the point is that you never know that your rights and your privacy have been violated. It was only in my case that we managed to establish that. And we argued, and the judge accepted that is a key weakness of the case, because you can never test whether your rights have been violated, because you never know about it. So he made provision for 90 days after the surveillance has concluded, you must be informed so that you can challenge the decision to monitor your communications if you feel that was done illegally. Obviously, there are cases when it's inappropriate for the person to know even 90 days after the fact. So the provisions that the judge has put in place make it possible for the state to apply to extend that deadline. But the basic position is that your privacy must be protected, and you must be told if it has been intruded upon.
And during yesterday's judgment, the judge also said that the Act actually fails to adequately address situations where the subject of surveillance is either a practicing lawyer or a journalist. Can you briefly elaborate for us on that as well?
Yes, look, both lawyers and journalists have duties of confidentiality. Lawyers to their clients and journalists to confidential sources. And the judge said that should be taken into account. And the judge who gives a surveillance order must be informed that the subject, the target, is a journalist or a practicing lawyer.
Now, Sam, what does this judgment actually mean for ordinary South Africans? Because the judge also suspended the declaration of invalidity for 2 years in order to give Parliament time to amend this Act. But, what outcomes do you expect from that process, and what does it mean for ordinary South Africans?
Well, look, we have the separation of powers here. So he said that where a law is unconstitutional, it's actually for Parliament to fix it. But as in many other cases, he said in the interim, in that 2 years that he's given Parliament to fix the problems in the law, an interim situation must be in place. We can't just carry on business as usual. And so he's made various orders for that interim period, such as the 90-day notification order. But there's another part of the judgment which has an immediate effect if it is not appealed. And there's a part of the surveillance architecture called bulk surveillance, which is essentially the automated surveillance by a computer of a whole spectrum of communication coming into the country and going out of the country, such as Skype, which we're using now. And in the past, the intelligence services have considered that where any leg of the communication is outside of the country, but that includes, for instance, Gmail, Skype, WhatsApp, etc. They can monitor that without any judge's ruling, without seeking permission from anyone. And the judge ruled yesterday that that was incorrect. There is no law allowing them to do that. It's illegal. And that ruling was not suspended for 2 years. That had immediate effect unless, of course, the state appeals.
So as it stands right now in terms of Rica, and since part of it has been found to be unconstitutional, just to clarify for the general public, is there any sort of accountability that needs to accrue to anyone in any part of this chain, or is it just a matter of this needs to go back to the drawing board and the parts that are found to be unconstitutional needing to be addressed?
Yes, look, I think the parts that are unconstitutional, he's put in place an interim measure which is going to affect people. If their communications are monitored, then at some point after that end, they must be informed of that fact. But the final version will be set by Parliament. But people should also remember this has got nothing to do with weakening of SIM cards and so on. That is unchanged. That part of the act is not unconstitutional.
And perhaps just a final question, as a matter of curiosity, Sam, this part that states that you need to be informed that your communication has been intercepted. If you don't know, what safeguards are there, for those who are doing the interception to actually let you know? Because if you don't know, you don't know unless you stumble across that information in one way or another.
Yes, that's the key point. So the state argued that the fact that they need to ask the judge for permission to carry out the surveillance, that was basically sufficient protection for you and me. But we produced examples where the police had lied to the judge, and he or she obviously didn't know that, and so granted the surveillance in a regular way. And of course, the person never knew. They couldn't challenge that. So this provision for notification, post-surveillance notification, is a key way of fixing that, because it can reduce abuses, because people will realize that they'll be eventually found out if they abuse the system.
So as it stands right now, there should be a host of people, I would imagine, who need to be informed that their communication was intercepted at some point. Any chances of you doing some investigative piece on that, perhaps?
Look, as in general, legislation and rulings are not retrospective. So it's not going to help those who were surveilled in the past. But unless this is challenged, it will help everybody going forward.
Very interesting. Sam Soul, thank you so much. Investigative journalist from amaBhungane investigative unit, talking to us about the court ruling yesterday that found parts of the Rica Act to be unconstitutional, and very interesting, of course, permutations that result from that. And of course, we'll keep an eye on those developments as well. Let's take a quick break.